Welcome to the 51A podcast, an initiative of the Constitutional Society of British Law.
Aayush and I
Here are gathered
with Professor Chinmay and Professor Rahela,
both in experts
of legal philosophy, both be it Indian or Western, and in architectural structure and sociology and legal fields.
We here are gathered on the topic of decolonization of Indian law, of Indian constitution. Talking about the same, the decolonization and Indianization of the legal framework is the highlight of the nation itself. With Justice Abdul Nazir talking about the same and pushing forward the idea of decolonizing the whole system as it is, to go back to Manusmriti, to go back to the Vedic period of law. And the CGI, the former CGI himself, Justice Ramanna, also pointed out that we should lose our colonial tendencies. We come back to these topics, and we have several questions that we would like to ask you, professors. My friend Aayush will start with the first one.
So we've been flabbergasted by how Indianization and how post-colonialization has, taken sphere in our country. So one of the first questions of mine would be, there are numerous ways of how we can define decolonization, and it itself is a point of contention.
Yeah.
So what essentially, according to you, is decolonization and Indianization?
Okay. Well, first of all, thanks for having us here. It's a wonderful opportunity to talk about, I think, a very contemporary subject. And as you both rightly pointed out, this word is a loaded word. It comes with a lot of different perspectives, sometimes conflicting, sometimes overlapping. But the way I understand the process of decolonization and Indianization, first of all, we must get into the meaning of the term. Decolonizing is essentially removing or uncovering a layer that was already in place and then looking at what remains, right? So the colonial layer that pervaded our legal system, that applied to our legal system, is different dimensions. That's something that we want to examine and uncover. And then we want to kind of look at more indigenous ways to probably rebuild that structure. So for me, the process of decolonization and Indianization is more akin to deconstructing and then rebuilding, or deconstructing and reconstructing. So you are deconstructing colonial vestiges, be it dressing, be it the language, be it different dimensions of the structure. And once you deconstruct, then you look into more indigenous, vernacular, local perspectives based on more local contexts, local experiences, which are rooted in our understanding, our cultural ethos and values. And you draw insights from there, right? Indian insights or indigenous insights. And then you rebuild that structure. So it's a process of give and take. It's a process of unlearning and relearning, for that matter. You unlearn some of the things that you've taken for granted and that continue to govern the legal system. But once you unlearn, you also have to rebuild and relearn a few things based on Indian experiences and Indian context. That's the way I understand the meaning of these terms.
So I think to take forward from what Professor Chinmay said, I think this just using of the words decolonization, Indianization, that itself is, in some level problematic. Now, if you read the work by, say, Mithi Mukherjee, she talks about how India continued in the shadows of empire. So even what we would mark, say, 1947 as a period of post-colonial history of India, is that actually post-colonial? Do we still, because of the way and what we are still following, say, take the legal system, right? We still have so many colonial aspects in it, which nobody is denying. And what Mithi Mukherjee argues is that India continues in the shadows of empire. Now, if you continue in shadows of empire, where are you starting that decolonization from? Where is it beginning? So whether you, why are you adding the word de? Is it colonization? Is it Indian? Which part is Indian? Which part? Again, when we came into the constitution, or when we adopted in 1947, when we made that shift, and what today we say when we talk about legal history, we say colonial period and post-colonial. Where actually are we drawing that line? Are we actually in a post-colonial time? We can't really say. So that's why I say that even using this word in this conversation, how are we, where are we, where do you draw the line, right? So were we a colony even when the Mughals came? Or were we a colony only after the British came? Were we a colony under the East India Company? Or were we only when we became under the Crown after the revolt of 1857? Which period? Where? And so colonization today, of course, see certain things, we have certain stereotypes. You think colonization, you think of the British, or you think of Western powers ruling other, say, developing nations, or say Africa, India. You have these set ideas, right? But is it only that? I mean, you can say you were colonized by the Mughal period from by Middle East, by the Central Asia, not Middle East, by Central Asia, right? So where, so I say I wouldn't even try to define, because the minute you define, then you're restricted in how you're going to now go ahead and interpret our courts, interpret our constitution. We're going to get restricted. So I think I wouldn't look at those two terms in that kind of solid way. And I think through our conversation, maybe we can come to that kind of an understanding as to what we today are talking about in terms of decolonization and indigenization.
That reminds me of a very interesting philosophical perspective, that post-modernity itself is a modernist construct.
Correct.
Because it always has to define itself from the modernist perspective. So perhaps in the same way, why do we define our own understanding of what comes after with the notion of what has happened so far? That itself, I think, is the problem that we need to address.
And I think defining things always restricts us.
Yeah.
And I think we're at that stage where we want to expand our understanding of our constitution, of our courts. That's the endeavor, right? That's where the Chief Justice is, where the government is moving. So why restrict? Open up that understanding.
But I'm talking about, for example, the recent westernization of laws. So there's a push towards now the Indianization of laws. And talking about the same, I'm quoting Macaulay himself, who initially brought the reforms in India, codified laws. He once said that I'll be the happiest person in the world when Indians themselves would enact these very codified laws. So essentially, in my opinion, this is my opinion, that we must go a little step back to something that we have as Indians before, for example, before the India was as a colony. So what direction should we go forward with? Should we change the whole constitution itself, or should we just amend some articles, or should we change the system, the architecture, the way it is formulated, the whole procedure? What should we change?
So I think there's many questions packed into that one thought. But the first thing that I just wanted to address as a segue, and then maybe we come back to the main question, is you mentioned about codification and how Macaulay said what he said. But we've studied in tort law, which both of us coincidentally did teach, is that entire, which the theme throughout tort law was the codification of it, right? So this idea that Macaulay is saying that Indians should codify, do we need codification? Is that required? Isn't that a Western concept? Does the Indian system, do you think that if we didn't codify all our laws, how would we work? We don't know, because we only have one understanding of the system, and that is codified laws, which is why even when we look at tort law and when we studied it in class, we always compared and said, okay, IPC is codified, contract law is codified, because there's the same debate, right? Contract law is not codified in the UK, but they codified it in India as an experiment, right? So you're thinking, okay, did that work? Today, how does tort law function? How does contract law function? Can you actually say in which way, how the legal system functions is codification? Has it helped you in what way, right? So that idea that you brought about, by even asking that question, it comes from some kind of understanding of a Western idea that codification is the way to go, when actually UK itself has not codified even its constitution, right? So where does that, why is that question even coming about? So that's my segue, in case you want to add something on that segue. Otherwise we go back to the main question.
No, I think that actually connects to the larger question, really, I think. Because when we talked about the process of unlearning and relearning, I think we have to revisit those even basic, what we refer to as epistemic categories. And why do we privilege certain categories over other? So our questions themselves sometimes will need reconstruction. The very question will need reformulation and refining, in that sense, I think, if you understand that. But if you take that question as it is, with its assumptions and its concepts, in my understanding, if we want to go ahead with this notion of decolonization and Indianization, we have to follow 3 C's: comprehensive, considerate, and also something that is cautious. What do I mean by these 3? When you think about decolonization, you have to think about it in a comprehensive way. You can't just think about redoing one particular law, as you pointed out, on one particular document, on one particular procedure. You'll have to really think about how do you start with deconstructing and decolonizing theory, decolonizing doctrines or substantive aspects of the law, and also decolonizing the process or the procedure of the law. And you really have to take all of them together. So, for instance, it starts with decolonizing our very syllabuses. So, what we are doing in legal theory, for instance, where we are introducing more indigenous Indian perspectives and introducing Indian theoretical perspectives on law. That's the first step. You start with the theory and its Indianization and decolonization. Then perhaps comes the second aspect, the doctrinal part or the substantive part, and we've again discussed in tort law perhaps what could be done. Is following the Western model, the Eurocentric model, is that the only way forward? Or can we think about an alternative mechanism? What are certain things that we can retain and what are certain things that we can let go? And we've done that with criminal law. I think we can discuss that further. But that's the substantive or the doctrinal aspect. And the third aspect is more about being cautious. I think we cannot go ahead with the notion of decolonization in a very haphazard manner, trying to undo everything that exists. I think we have to be considerate in terms of making incremental changes, looking at one thing at a time and trying to kind of readjust it based on local circumstances without radically disrupting all expectations and understanding that the nation has.
So maybe if this is the time you want to enter into what Professor Chinmay mentioned about the criminal law, maybe we go into that segue. So as we know, in July, you're going to have the new laws and there's a lot of debate and discussion. So for the bulk of it, it's almost the same. The laws are not, they've not been much changed. There are some things that have been removed, some fines and things that one can argue could have been added as amendments. You do not need to rewrite or overhaul. But of course, there's also the optics of it. There's the idea of it, that this idea of decolonization, we don't want this Indian Penal Code from 1860 on all these acts, and is the Evidence Act 1872, all of it from the colonial time, which has carried forward. We want to show that we are now, moving towards, and then of course the renaming of the acts itself, right? So you're not calling it the Indian Penal Code anymore. You're giving it a local, language name, Indian language name, okay, I would say. So you're doing all of that, and so the message is more loaded than just of the changing of the act. Now, if you were to maybe look at studies in India and have done studies on, say, death penalty, and then incorporated those sociological aspects of death penalty into it, then I would say you have moved away from some colonial aspect or from something. So, for example, if it was very radical, I'm not proposing this idea or denying it or anything. I'm just saying that, for example, if our new penal laws took the approach of having no death penalty, for example, that would be something where you can then argue that there is a change in our understanding of the justice system. Otherwise, we are not really making anything different. So, if I was to say no death penalty, open prisons, different ideas. So where, is that now?
If I could add to the same point, moving on to a more specific aspect of criminal law and its decolonization, I think what you were mentioning, how it has to reflect a more anthropological, sociological understanding of the context, and probably that translating into the modified decolonized law. If you look at it from that perspective, I think the changes in these acts are a bit more cosmetic rather than substantive. If you really look at the 3 C's that I just mentioned, in terms of the process, I think it could have been made a bit more accessible, it could have been made a bit more vernacular, right? Or in terms of morality aspect, right? As Justice Chandrachud mentioned in many of his judgments, Victorian morality continues to govern our understanding of criminality. Why is that? Is there any different perspective that is more indigenous, that is more vernacular, that can help us again move away from or beyond Victorian morality of, let's say, gender norms, sexuality, gender expectations? How does that mean for some of the provisions in our IPC? If more attention was paid there, we've retained, I think, in the new codes also the idea of marital rape. Again, was there, could we have done something based on our local experiences to perhaps come up with a different understanding. I think that would have made for a more substantive, in a real sense, the idea of unlearning and reconstructing.
Yeah, so I just recollected what I wanted to add, especially about this data. There was a recent study on the death penalty data sociologically, in the sense of what are the number of people from which community and the class of society that maximum death penalty is given. So it's always from a minority community and always a lower class. So
Even under trial prisoners, I would say.
yeah, so that's your category. Yeah, in the same category. So that's so. Have you incorporated that? Have you looked at that? That's the, if you want to look at India as decolonized, you need to look at its social structure, how it is today. And today's India, 2024, if you're talking about, that's our social structure. That's what the data is telling you. The actual hard data is telling you that this is how your death penalty is working out, right? So if you want to actually decolonize, that's where you should be bringing in change. You can change the law, but if you're going to imprison the same people and the same people are going to be under trials and the same people are going to be given death penalty, then where have you moved, where have you shifted, then it doesn't matter, right, what you define as what, because actually what's happening. So I feel like you need to see tangible change, and in fact for that you don't need to amend a law. For that your ethos need to change. You need to break, right? And so the law changing comes, like I would say,
Perhaps
in
the
section last, because like section 377 was decriminalized long back. It's now when they've amended it that they've removed it, right? So that's the last stage, but it's already been decriminalized for so many years, right? So I think that comes in the end. Whereas
That's why I think the epistemic or the cultural decolonization must precede, I think, legal decolonization.
I think, sir, the Attorney General as well, I think he mentioned that we would be changing the entire syllabus of the law school after these amendments or after these bills are brought in. So do you think that it will change the law school aspect, as ma'am mentioned, that it will not change the process as much or the procedure? So him mentioning that it will change the law syllabus and the way of teaching, would it be affected after the new laws?
I think way of teaching does not change. The syllabus changes because you, from Indian Penal Code, you will have to study whatever BNS or whatever the name is.
Most provisions are, I think,
and the
identical.
same. So the theory of the criminal jurisprudence remains the same because that has not moved, right? That's what I'm saying. That has not changed. You might now you will say that's the joke, right? 420, like 420 is no more cheating, and all your Hindi Bollywood movies, everything's like 420 and the Coolie, whatever that all of that goes. So they're like, oh, those jokes that you make in court and you come to court and say all that will go because you'll have to remember a new number, but that is not. That's cosmetic, right? That's not substantial. Your criminal jurisprudence is the same because you're still giving death penalty. You're still holding marital rape in the same way. Your understanding and definition of rape is the same. Domestic violence, dowry, death, all of that is the same. So where have you realigned that to your social justice system? Not necessarily. Have you incorporated open prisons? Have you made your criminal procedure easier so that people don't get stuck into under trials? Have you made things better for under trials? That's where your criminal jurisprudence comes and sits, right? That's your core. So, I mean, I don't see that. I don't think it'll change. Syllabus will change because, of course, when you buy the Bear Act, you'll be buying a different Bear Act, so I'll have to update the book that you have to purchase, right? But I don't think the jurisprudence of it is changing much.
Philosophy needs to change.
Philosophy
I think fundamentally, just to kind of put it very briefly, the criminal laws, IPC, CRPC, were enacted in the context of 1857 revolt. So the idea was subjugation, control, surveillance. Now, if that philosophy is not changing in the new laws, then fundamentally teaching approach syllabuses won't have to change. Because if you are still retaining sedition, if you are still retaining the idea of control, extended custody, the idea of fear, then I think probably jurisprudentially, we are still the same.
I mean, you're studying Bentham, you're studying Panopticon, Foucault. It's all going to continue, right? Because we're still surveillancing, we're still watching, and we're still.
There's this argument that is prevalent these days that because we retain the same IPC, we retain the same civil services exams, IAS, APS. Essentially, we are not changing after the colonization, and we are going back to the same old procedure, and it's not guaranteeing the rights, but a surveillance state, as you mentioned. So what can be the alternatives to this system? I mean, if we want to hold back the constitutional morality, so to say, or the essential features, for example, democracy, or separation of power, but also retain or incorporate some of the Indianized features.
Yeah.
So where should we go back to? in this sense? Should we go back to the Mughal era? Should we go back to the Vedic period, or should we go back to the...
Well, that comes back to your definition, right? Depends on where you start the definition of decolonization. But why don't, if you want to go first. on
Well, I
this.
mean, I would just say, this either or yes and no approach is not going to be very effective in our context. I think this nation is incredibly diverse with very rich and diverse history. So what I would suggest is, rather than simply decolonizing, we need some sort of adaptive decolonization, where, I mean, if you really go back into history, you'll find that there are a lot of similarities between Ashoka's edicts, for instance, and Roman 12 tablets or 12 tables. Cultural exchange has been a process that's been going on for millennia. So can we really call colonial as alien? And is there something that is truly indigenous? Can there ever be such a thing as completely isolated indigenous idea?
Right, yeah.
And once we revisit that and we realize that there has always been exchanges and intersectionality there, then we need to understand that we have to decide, not only from the colonial perspective, but also from pre-colonial times, what to retain and what to let go. I think that's an intelligent exercise that we'll have to do, not only with what the British brought, but also from all of our cultural baggage. What is it that we want to retain? What is it that we want to let go? So the unlearning is not only with the English language or the English legal system or the English architecture, but also everything that really precedes it or leads up to it. And that, I think, is a much more profound and a more demanding exercise, and will need a lot of intellectual and other resources.
So just to pick, I'll take one part of what Chinmay said, because you asked me in the previous question about the architecture, which I didn't address. So like I was thinking, like, you can't do this overhaul, and you don't want to also kind of be like, okay, I'm going to remove the constitution, I'm going to rewrite the constitution. That's not, because like we said, where is that Indianization? What's the start point? What's the end? So we work towards from what we have right now. And you can do small things, you can do big things. So I would say rewriting the criminal laws, that's a big thing. It could be done in different ways, but let's say now that's been done and that's your one step in that direction. But then there are small things, right? So that's where my work and my field work comes into the picture, where I'm looking at how certain colonial cultures in the colonial former erstwhile colonial courts of Calcutta, Bombay, Madras, how certain colonial cultures are practiced. Now this is not in some written law, these are cultural things that are happening in court. And of course, I argue the building, the colonial construct, all of it kind of influences. So let's take an example of the dress. One example. If we can let go of wearing the band and gown or the black and white, say today, simple reason, the weather. The weather in India, across India, it's so hot in the summers, it's such extreme. Wearing black doesn't help, and double black, right? You got to wear the black jacket and the black gown. The band, if I ask you, okay, you're a law student, but if you ask the senior most counsel to the junior people, nobody knows why you wear the band, what's the historical origin, what's the relevance, what's the significance, what is it, we don't know. So you're following something very strictly, like wearing the gown band, when most people don't know the reason why. So maybe you can start. So decolonization / Indianization can come in multiple ways, right? One of the ways is you just say tomorrow, if I change my dress code for court, if I just change that, can that also help? Can that start contributing towards a change in mindset? And it's not only about colonial, right? So wearing of the band is also a gender problem, because the band presupposes that you wear a collar, and most Indian women's clothes, they don't have a collar. So many times judges have a problem. If a woman, if I'm wearing what I'm wearing right now and I go to court, if I wear the band around my neck, they have a problem. They say you have to have a collar. So now women in certain courts, they make sari blouses, or they make the blouses which have an inbuilt collar. Or for example, in the Madras High Court, they've innovated. So that's, I think, a form of decolonization, a step towards it, wherein they have innovated and they've made a band. If you see it, the band has the collar stitched into it. So when you wear the band, otherwise you're tying the string. In that case, when you wear it, the collar is the string. So it looks like you're wearing a collar and the band is attached to that. So that is also a form of decolonization, or actually Indianization, because Indian women's clothing does not have, like if you wear a Western female wearing clothing, you'll have a collar, right? So that's a form of Indianization where you've adapted but can you now still move forward and let it go? Can that also be a form? Do you have to have a dress code? Why do you have the dress code? Now you talk about Macaulay and subjugation, but this form of having the dress code, enforcing it is a different form of subjugation within court to show power, right? It's a way of showing power that we are, a lot of lawyers were like, we don't want to let go of the dress code. Why? Because it shows the difference between us and them. So you are doing your own internal subjugation, right? So when you talk about Indianization, there are so many ideas you have to let go of. But the other question is subjugation only a Western concept? Is it also an Indian concept? We have enough of our own internal subjugation. So that's why, how do you define where do you stop, where do you start? But I say small things. I really think that you could let go of the dress code. During COVID, on Zoom, when court was on Zoom, they had given an order that you don't need to wear the gown. So you were appearing in Supreme Court everywhere without the gown. And I actually had a hope and thought that when court will resume, they'll be like, okay, justice was happening in the same format and everything was followed. So did the gown change anything? But as soon as they open physical courts again, it's back to the norm, right? So couldn't you have let go of that? Like how relevant is that to your access to justice, or to your delivery of justice, or to the approach to court, and all of that?
So even the way I think this hierarchy is made.
Yeah,
I think
and when UK redid their Supreme Court recently, I mean when they've shifted from House of Lords and now they have the UK Supreme Court, they have a design guide, they have all of it, also problematic, but they have now made everything at the same level. Now we inherited this from the West, but they have let it go. They still have problems of hierarchy and things, but they've made the acoustics such that everyone can hear each other, and they've given equal space. They've actually, like if you say otherwise in courtrooms, judges have the most space in proportion wise for the number of people using the space, and then the staff, and then lawyers, and least spaces for litigants, almost no space. So what is happening in UK now, the Supreme Court, they've made it all flat. So the hierarchy is not there, and actually this is also not that much of a hierarchy. If you've been to the Bombay High Court, it's much higher, right? So it's a high pedestal. That's flat, and UK has made it. Supreme Court has made it flat. So there are ways. I mean, you do renovations in buildings because of infrastructure falling, and why don't you overall do one court at a time? You don't have to do all. You can even then do a study and see whether how is justice being treated or observed or being viewed in a court that's flat versus a court that's in a pedestal, right? Can you actually make a correlation? Is there any difference? Was there a difference when you were on Zoom in the way I'm not saying the process. Of course, you have to do e-filing and you had other problems of COVID. That's not what I'm on. I'm on the end interpretation of the law, interpretation of justice, or what you were asking for. Did that change in any way? And if it didn't, then do we need certain things? Because these are things that keep the lay people out of a justice system, because you get fear. Like I spoke to people, right? They will say, feels like lawyers are bats, walking down corridors of courts like with these things, or they're like magicians who have this superpower because they have these walking. So why is that the approach, or do you want to be approachable? Then that's where you define what is Indianization approachable? Is it subjugation? What is it? So where do you then you start defining?
So I mean, if you look at the code of conduct as well, code of conduct aspect of the code. So if I argue that the pedestal is made in the form as it is for the code of conduct to regulate the codes, so that there's no ruckus in the form created among the board.
Or the gavel.
Yes, because we see in the news that every day or now and then there are instances of violence happening inside the courtroom. So I think the court ethics or the pedestal, can't it argue that to form that regulation we need such restrict code?
I think the direct answer for me to that question is look at your social situation around. Why are people being violent in your court? If you address that problem, you should not have a fear to be fully approachable. So vague kind of correlation and comparison, but way back till Indira Gandhi was assassinated, actually the prime ministers, of course times are different now, I'm just giving you an example. Prime ministers used to not have this security entourage, at least she did not. So her doors were actually always open, and anyone could come and speak. Any person was allowed to come and speak some grievance, and if they had, so she was her office was very open and approachable. And that is also the reason why they were able to easily kind of penetrate and assassinate, right? Because she didn't have much security, and her philosophy was that open, because it's people should come, and that changed. And now of course it's not possible, right? So that's the question that you have to ask, right? That as a judge, if I'm sitting and there is violence, where is it coming to? Like, where is it coming from? What is the dissatisfaction in society? Or are my legislations not robust enough that they are not able to cater? Is it the pendency in courts? Is it the lack of judicial infrastructure? It could be as simple as somebody has traveled from the interiors of Maharashtra to the Bombay High Court. There, you went to the court, you saw there's lack of space, there's no benches, there's not proper toilets. It could be just frustration, it could be you're fully drenched and soaking wet in the Bombay monsoon and you have come, and I know there could be so many reasons. Once I was following some cases when I was doing my field work in the Bombay High Court, and there was a person who had approached the court, had filed a public interest litigation, and he had asked the court, he said that I feel like I'm a flamingo and I want the court to adjudge that I'm a flamingo. Now, everybody in the court was so upset that they were even hearing it. But what some people told me is that you should actually wonder why this person has come to the court asking for this. If someone is coming to the court, now we can maybe laugh or have a smoke about it, but think of how problematic. Don't you think that that person should obviously need some kind of help, right? And if you're coming, no other forum was helping you, you've come to the court thinking, so at least if nothing else, a court can maybe at least give it a hearing and say, okay, maybe this person should need some medical help, or go to the root of the problem and find out why, because today that person is standing in front of you for some form of help. And justice comes in different ways and forms, right? Justice can also mean helping someone sort out a mental issue, which kind of makes them, different form of justice, right? So that's what I mean to say. If you ask why the violence, what is the reason? If you just bring that person, be like, why are you so upset? Because if I'm going to be violently attacking a judge, when I know there's a code of conduct, I know there's contempt, I know I can be put in jail, I know, the court is always telling you it's a sacred place, it's a temple, you have to bow, you have to venerate. If I'm still being violent, I think it goes to us as a community, as a society, as lawyers, as students studying law, as professors doing the theory and jurisprudence of law, as to why is it happening. And I think if we can address that, we can understand the Indianization, or why Indian courts may be more violent than other courts, or go back.
Right. No, I agree. I think I would just I would add maybe another point
Dimension.
to it, or a dimension to it really, is that while I agree that we need to go into the root of this problem, but I would also say at the end of the day we need to find that golden mean, as Aristotle would put it, that there are certain ideas which are universal and perhaps necessary. The idea of safety and security, as you pointed out, that's a consideration that we cannot ignore. But we also need to acknowledge what really calls for that safety and security. So it's really a balancing act between, again, realizing what things to retain, as I said, and what things to rework and have a relook at. So
I think it comes down to that, what from it you want to retain,
Yeah.
what you want to.
Yeah.
I think when we talked to Upendra Bakshi now, he also mentioned that it doesn't matter if we took this thing
Yeah.
from this part of the world, or
Correct.
we took this thing from that history,
Yeah.
as long as it retains, as long as it serves its purpose. And he sang a song, he said, "Mera joota hai Japani, but tum Hindustani.
Sar pe laal tohi Rusi."
Sir pe dil hai Hindustani.
Yeah.
So I think it boils down to that.
Yeah, I agree. I think
Yeah.
even Fali Nariman used to say, English language, we have indigenized it now.
They say Hinglish, right?
Yeah.
They call it Hinglish,
Yeah,
and they have
yeah.
all these like.
So I think this nation has always been very syncretic, and our food, our clothing, our language, our dialects, I think we've borrowed from a lot of things, and it's not necessarily a bad thing.
He's gone on to say, Professor Bakshi, that it doesn't matter how long and how much you borrow,
Yeah.
but it matters the quality of
Yeah.
how much you borrow.
Yeah.
And you have to, anyway, whatever you borrow, you have to adjust it to your
Yes.
culture, to
Yes.
your fitting.
Yes.
If it fits, then very well, you can continue perhaps. Probably.
Absolutely.
And I think it's not only, say, taking from West or this, I say within India itself, from rural to urban India, you have decolonization.
Yeah.
You have decolonization within ourselves. You have cultures you're taking from there. Someone who comes from there comes to the city. You have to adjust.
Yeah.
A court in a rural area is not going to be the same as the Bombay High Court, how it's functioning here, right? So you will adapt, language is different, everything in the same state, right? But you'll hear English in the Bombay High Court, you will not hear it in a district court. You'll hear Marathi over there. So internally, I think we are Indianizing and decolonizing within ourselves itself. So even from, say, a state to the central level, so Supreme Court is very different. Again, when you go there, the kind of cases you take there are also different. So it changes, right? So I think.
So we've had a wonderful discussion.
Yeah.
We've got a good aspect into how it is required in some aspects, and if we can continue perhaps with the colonial laws in the way, in that sense, we could still perhaps continue. And on behalf of Pranjal and I, the podcast committee, 51A podcast committee, and the Constitutional Society, we thank you, Professor Rahela and Professor Chinmay. This is the first podcast,
Yes.
and we are really happy and we're really grateful for your time.
Yeah.
And we hope that this continues and we can have many podcasts in the future. Thank you so much.
And yeah, and congratulations on your first
Yes.
successful
Thank you.
recording.
Thank you so much.
And
I think-
hope for many more.
Yes, I agree. I think it's a wonderful initiative.
Yeah.
And I hope many more interesting podcasts will come. Thank you for inviting
Thank you.
us.
Thank you so much.
Thanks a lot, sir.